morning. May it please the court. My name is Brian Nichols. I'm from the Loudoun County Bar.
I'm going to ask you to speak up a little bit or maybe pull that mic closer.
Usually that's not a problem for me. I'll do that. Brian Nichols from the Loudoun County Bar. I'm happy to be in this fabulous courtroom today, considering we don't have one in Loudoun County since it burned down 4 years ago, and we're having trouble getting that back. But it is a pleasure to be before you this morning. I'm going to do something that I normally do, and that's be fairly brief here. The issues from this case stem from a DUI arrest, and I'm not going to dwell on a lot of the basic principles of the law that you're very familiar with. I'm just going to talk about these facts a bit. But the two basic issues is whether the trial court erred in denying the defendant's motion to suppress, and it has to do with a blood draw. And the second issue is whether a rational juror, considering all the evidence in this case exclusive of the warrantless blood alcohol analysis, could have found beyond a reasonable doubt that the defendant was guilty of driving under the influence. The events that led to this ultimate appeal began with an arrest early in the morning, March 2019, 4:47 a.m. I believe to be exact, where Mr. Timothy Davis was on his way to work, where he worked at a business called Carlex, which I'm sure Judge Witt is familiar with in Monroe County. It's part of the industrial park where he had been on that job for many years and going about what he called his same routine. The issue presented here today is whether or not there is sufficient evidence in the record for the trial court to have denied his motion to suppress based on what the court defined as exigent circumstances, which the court notes as an exception to the right to be free from unwarranted searches and seizures. Of course, the court, as the court is well aware, Mr. Davis's rights are protected in that he has an absolute expectation or a right of privacy and the drawing of his blood, and I think the courts have been consistent with that concept for a long time now. But to bring the case, I guess, clearly to what it boils down to is essentially what happened is that Mr. Davis was angry at this officer right out of the chute, and it was clear from the entire transcript, I believe, and from the trial, that he was angry because he thought he was going to be late to work. And it starts out bad as soon as he pulls him over. What are you doing? You're going to make me late to work. And it kind of went downhill from there, quite frankly, with some name calling and a few other things. And Mr. Davis was arrested within a pretty short period of time from the onset of this first initial stop. The exact times I have noted in my brief, but in essence, Mr. Davis was first of all asked to do some standardized field sobriety tests. The traffic stop was initiated at approximately 4:30, just to be clear about that. And I think importantly, Officer Millsaps, who's the arresting officer, noted that he immediately smelled alcohol on his breath, which would not have delayed any part of the investigation to determine whether or not there was probable cause, whether to make this arrest or not. The cases that have found since McNeely any sort of exigent circumstances have been pretty narrowly construed. I think there are only two instances since McNeely, which I believe is a 2013 case, where the court did find exigent circumstances. And in both of those cases, the common denominator was there was some event that led to a delay in the officer's ability to begin conducting an investigation as to whether or not there's probable cause. And I believe in both of those cases, which I believe was Oak, and I think is one of them. But anyway, the point being is in both those cases where exigent circumstances were found, I believe it was the case that the defendant was undergoing some medical procedure related to some injury, but there was a pretty significant delay in between the time that the officer pulled this person over and he could begin to try to develop any sort of probable cause through his investigation. Here, it's pretty clear that from his testimony at trial is that he smelled alcohol, and he says, and very quickly began his investigation as to whether or not Mr. Davis was under the influence of an intoxicant. There were some different conflicting, disputed testimony about why some certain things happened during the trial. Like in, I think, every DUI case I've ever tried in my life, one of the contentions was that Mr. Davis was unsteady on his feet. Mr. Davis testified that he had a condition that caused his legs to hurt, that the jury could have believed, I believe. Also, he says that when he got out of his vehicle, there was some uneven pavement that caused him to stumble when he got off the side of the road when he first got out of his car. Mr. Davis testified that he did pull over because he saw Officer Millsaps enter the industrial park at a high rate of speed with his blue lights activated, and he believed he was trying to get around him. And Mr. Davis, when he pulled over and was asked for his license, told the officer, "I have the paperwork," and what that really translates to is he didn't have a license. What he had was a signed application from a judge to get a restricted license, but I don't think he had taken the necessary step to go and actually go to the DMV and have that processed. Given the smell of alcohol and observed unsteadiness, Officer Millsaps attempted to conduct a walk and turn test. And Mr. Davis began the test before Officer Millsaps even finished his instructions, because as he stated many times at trial, I was trying to get done with it so I could get back to work. In any event, at about 4:47, he was placed under arrest, and Officer Millsaps had to wait there for a tow truck, which is the routine situation when you have there working an arrest by yourself. But a kind Von Orr police officer showed up and said, "Go ahead and take him on to jail on your arrest, and I'll wait here at the scene for the tow truck." And that occurred at about 4:57. So about 10 minutes is passed from the time he was arrested and he left to take him to jail. Mr. Davis arrived at the Monroe County Jail at roughly 5:32 a.m., a little over an hour after his initial contact with the officer. The breathalyzer was out of service. He refused to consent to a blood draw, and at that time, Officer Millsaps began drafting a search warrant for his blood draw. And I believe that's because he knew he needed one. At that point in time,
so
Officer Millsaps...
Your position is that I understand it, the exigent circumstance rationale fails because your client was already under arrest based upon probable cause.
Correct.
Does that make any difference in the officer's right to try to get a blood draw?
I don't think it makes a difference in his right to try to get a blood draw, but I think it has a bearing on the analysis of whether or not the officer did, quote, all he could in order to comply with I believe the Tennessee constitutional requirement to obtain a search warrant for the draw of this person's blood. But I'm looking at it from the standpoint of the two cases that narrowly found exigent circumstances, and in both those cases, there was a delay in that investigation to determine whether or not there was probable cause for the arrest. There's no such delay here, and I think that's the key difference. But I don't know that it makes a difference in terms of whether or not he tried to apply for a search warrant or not. But if that answers your question. In any event, Judge Dwayne Thomas, the General Sessions Court Judge of Monroe County, was attempted to be contacted at that time. And I think to be fair to Officer Millsaps, I believe his testimony was he tried a few times. And at that point in time, he contacted the on-call person from the district attorney's office, who advised at that point in time that to go ahead with the blood draw under the doctrine of exigent circumstances. He did testify, Officer Millsaps, and admitted that he could have driven to Judge Thomas's house in 15 minutes, I believe, and he didn't make any attempts to call any of the other judges who would have been qualified to sign that search warrant in that district, including the presiding trial court judge, in this case, who is Sandra Donahue, or Andrew Freiberg, the other circuit court judge, or any other of the circuit court judges.
So wasn't there some pretty significant geographical difference in where they were all located.
I think that's right. In other words, I believe, and I don't have a map to their house or their address, but I believe both Sandra Donahue and Andrew Freiberg live in Bradley County.
Well, I think everybody on the trial court benches down there at the time were in Bradley County.
I think that's right.
And that is that's a pretty good ways away.
Agreed. At the time, Judge Thomas was living in Sweetwater, Tennessee, which is much closer. And, the officer also testified that it would taken him about, I think, 40 minutes to draft the application for the search warrant. And my contention is that in that time frame that he was actually doing that, and then after he even finished the application for the search warrant, there was roughly an hour or so passed before the blood draw was even conducted. So in that hour, that dead time, he could have driven to Judge Thomas's house and stayed for 20 minutes and drove back, and not been any difference in the time frame in which Mr. Davis's blood was drawn. And, interestingly, I believe that same morning he went before Judge Thomas to be arraigned. Sometime that morning, I don't recall exactly when, but it was sometime around 9 o'clock that morning. So, it wasn't like Judge Thomas was on another planet. He was available. He was just, I guess like the rest of us, sometimes I don't answer my phone at 4 o'clock in the morning because I get it turned off. But I don't know, I understand judges have a little bit different responsibility there. But in any event, we would submit that the blood draw itself was .27. That was the reading of the BAC. And quite frankly, Mr. Davis caused me to immediately file a motion to preserve that blood sample because he just could not believe it was that. And we had that blood sample preserved, and we had it retested at a private lab, and it came back a little bit different at .24, but also a similar number. And I thought about that was driving here today, is what is the effect of that on this case? And I really don't think any, because I think that once his blood was drawn, I believe in violation of both Tennessee and federal constitutions as an unreasonable search and seizure that doesn't fit one of the exceptions. I believe that it doesn't really matter that he had that same sample tested again. It's not like he produced new evidence. He didn't produce new blood from a draw. It was blood that had already been taken, I submit, illegally by the state and preserved. So I don't think that creates a problem for his argument, but you may disagree. The court, as the court is aware here, this is a consideration that at the time the judge had to determine basically on the totality of the circumstances. The courts have said that the mere natural dissipation of alcohol in the blood may be considered as a factor, but is not enough to create an exigent circumstance necessitating a warrantless blood draw. The case in McNeely, court in McNeely, said special facts such as an intervening accident investigation are not necessary to justify a warrantless search, but some kind of factors that dilute the opportunity to obtain reliable evidence must exist. But there is no such impediment here for him to determine reliable evidence, and that his investigation began almost immediately, unlike the two exceptions that happened since McNeely where there was a delay in that investigation. I contend that there were not any special facts involved in the stop, nor were there any outstanding circumstances involved with the routine nature of the traffic stop that would affect the totality of the circumstances determination in any meaningful way. Again, I would reiterate that Officer Millsap was relieved by the Von Orr police roughly 10 minutes from the time frame that he was waiting on that tow truck, and that it was possible and should have been done that Officer Millsap could have driven to Judge Thomas's house, or at the very least, there are Monroe County Sheriff deputies that could have been other sheriff deputies who could have been in the area of Judge Thomas's home that could have been called that morning to go to his house and knock on the door. I think these officers have a greater responsibility to our Constitution, both in Tennessee and federally, than just to make a phone call and ignore it at that. The last part of my argument has to do with basically Officer Millsap's testimony was that the standardized field sobriety tests that were submitted were not really conclusive, that the real basic reason that he arrested him at the time was for safety issues, because on that road, people were coming to work, and he was just trying to get off the road, if you will, and began his investigation. So I would submit to the court that the video evidence is not dispositive in this case. There was some testimony at trial and questioning from the state's expert in terms of how that would have translated in Mr. Davis's appearance at trial if you looked at it extrapolated, because if his blood alcohol was 0.27, the testimony at trial was that at the time of his initial arrest, his blood alcohol would have been well over 0.30, and there was testimony that oftentimes when people's blood alcohol content is that high, there would be people passing out and those kinds of things, and none of those things existed at trial. And so for those reasons, I would submit to this court that a rational juror could have and would have found Mr. Davis not guilty if it were not for this blood evidence.
Well, let me disabuse you of the notion that chemical evidence would not be considered in our analysis of the sufficiency of the evidence. That is part of the formula for sufficiency of the evidence, even if we found it to be illegal.
Understand?
And so it provides a basis for sufficient evidence to convict your client of DUI, even if we found the blood draw to be illegal. If we found the blood draw to be illegal, we would reverse the conviction for a new trial, but not dismiss the case based on insufficient evidence.
I understand.
That's the way that works. Okay?
I've got a quick question. The state points out there's some errors with the judgments, and I looked at them, and I tend to agree, and I just wanted to know if you had any disagreement with that.
I don't believe I do. I haven't recently reviewed them, quite frankly. One thing I did want to point out is that one of the oddities of this case is there are some weird time differences between when this, for instance, we tried this case July 22nd, 2021, and there was a motion for new trial was not filed until February of 2022. The reason is I think on July 23rd, 2021, I paid for and ordered the transcripts, and there was some problem of me getting them, and I don't remember what it was with the court reporter. Something happened.
When was the judgment entered?
Well, the judgment would have been entered after, let's see here. The motion for new trial was filed by Mr. Davis on February 24, 2020. A hearing on the motion was held October 14, 2022, and subsequently denied. We filed a timely notice of appeal on November the 2nd, 2022. The appellate record was filed. I'm not sure from that language. I don't have an independent recollection of actually when that judgment was filed, but it would have been, let's see. But the thing I just wanted to point out was that from the time frame between February 24, 2022 and a hearing on the motion, October 14, 22, the reason that's so much of a lengthy time there is...
So the motion was filed from July to February.
Well, the motion
after the trial. The trial was in July, motion filed in the following February, but you don't know when the judgment was entered.
I don't recall that specifically, but a motion for new trial was filed February 24, 2022, and we didn't have the hearing on that motion until October of 2022 because Mr. Davis had some medical emergency where he was hospitalized for many months. I just wanted to clear that up.
Well, the two critical dates on that, from the standpoint of our jurisdiction, is the date of the judgment filed vis-a-vis the filing of the motion for new trial, which must come within 30 days after the judgment is filed.
Right, and I'm sure we were in compliance here.
Well, the record will reflect that.
Thank you.
Thank you.
Thank you for listening to me.
Thank you, sir. General, do you know the answer to that question?
I do not off the top of my head. I do remember looking at it and concluding that it was timely. I think there was some issue that delayed some of the dates. I don't remember off the top of my head what actually those were, though.
You don't recall that you examined a record for the purposes of determining this court's jurisdiction?
I did examine it for the purposes of determining the jurisdiction. I do not remember what caused the delays, because I do remember seeing the dates and thinking that it was odd. And when I looked into it, I concluded that it was timely and the court did have jurisdiction, but I don't remember the details of what caused the delays in those dates.
Well, like I said, the record will tell us the answer to that.
Good afternoon, or good morning again, Your Honors. Abigail Renard for the state. This court should affirm the defendant's DUI convictions. First, the officer here was presented with a potentially dangerous situation where he had to prioritize safety over drafting a warrant. And the trial court correctly looked at the totality of the circumstances and concluded that the warrantless blood draw was supported by exigent circumstances. And second, the defendant's blood alcohol content was 0.27, well above the legal limit, and this evidence was sufficient to support his DUI convictions. So first, going to the exigent circumstances issue. Considering the totality of the circumstances, there are several factors that combine here to create exigent circumstances. And I think first, it's helpful to go through some of the explicit factual findings that the trial court made. So first, once the officer developed probable cause to arrest, the trial court concluded that he had, quote, all of this other stuff to manage and did not have the technology to do anything other than what he did. So he is dealing with a situation where he's on the side of a busy road, and if you look at the video, you can see that he's on a 2-lane road at 4:30 in the morning when a lot of people are going into the industrial park.
That's so not uncommon to what officers experience all the time when they pull people over. So is that all?
That is not all, no. So he's on the 2-lane road, and you can see that cars are having to go into the other lane, and so he's by himself, he's on the road, he has a defendant who is admittedly angry, as opposing counsel noted, but also stumbling into traffic, and there was testimony that he kept trying to wander into traffic. So the officer is by himself trying to make sure that an accident doesn't happen and trying to make sure that the defendant is safe, that he is safe. So he's dealing with all of that. And then the trial court also found explicitly that although the officer could have typed in his car and that he couldn't have started drafting the warrant any sooner. And then he also found that contacting another judge would have taken another 1.5 to 2 hours. So these are the explicit findings of the court. And so the officer had to prioritize safety over the warrant application, as I said. And then because of the time of day, traffic that was going on, and the availability of the judge, getting a warrant took more time than it might have at a different time of day.
Did the trial court, I'm sorry, did the trial court address the efforts made to contact the judge?
Yes.
I know there was testimony that there were a few phone calls, but nothing more. So how did the trial court deal with that?
So the way the trial court dealt with that, so I'll just go through the whole timeline. So around 4:30, they get the call. He arrests the defendant at around 4:47, and then is dealing with the scene, dealing with the inventory, all of that stuff. They go to the jail. The defendant gets booked at the jail, and pretty much right immediately then, the officer begins drafting the warrant.
Okay, now the defendant argues that the officer had already built a case for DUI before he even got to the jail, and that a blood draw would be superfluous, and because of that, there could not be any exigent circumstances to obtain one. How do you address that?
So I think that development of probable cause is obviously a relevant determination. This court has held that it's a relevant determination, but it is not determinative, and it's certainly not determinative in this case. McNeely and Martin McNeely and Mitchell, do not stand for the proposition that immediately once you get probable cause, then there cannot be exigent circumstances. And this court has, in Martin, there was an acknowledgement from the trooper in that case, where the trooper had testified that even if he had suspected a DUI sooner, it would have not altered the timeline of events at all, because he wouldn't have been able to draft the warrant any sooner. And so in that case, there was an accident, so it is different factually, but there are circumstances where developing probable cause isn't going to impact your ability to get that warrant sooner. And this is one of those cases. As I said, the trial court explicitly found that the officer couldn't have started drafting the warrant any sooner. He was doing things as quickly as he could. And then once he had the warrant, which again, the trial court found was as expeditiously as possible, he tried contacting the judge, to go to your question, Judge Ayers. And the testimony was that he tried to call the judge, I believe 4 or 5 times, and the judge didn't answer. He couldn't get a hold of the judge. And so the court essentially found that it was a pretty reasonable conclusion that when you're calling somebody and calling a judge repeatedly around, I think he started calling around 6:15 or 6:30 in the morning, and could not get a hold of the judge. The judge wasn't responding. So it was reasonable to conclude that for whatever reason, that judge was not available at that time. And although he did testify that he could have driven to the judge's house, that's not necessarily reasonable to assume that the judge would have been available when he is not answering his phone. And that was the court's conclusion, was that the officer here acted reasonably under the totality of the circumstances. Could he have driven to the judge's house? Potentially, but that could have taken an extra 40 minutes plus the time that the judge would need to review it, and that's assuming the judge is even available. Could he have gone to a different judge's house? That would have taken an extra hour and a half to 2 hours. And at this point, it was also, the court also noted that this was pre-COVID, so the technology was not as accessible at that point, and so the officer had to actually appear before the judge. And so in this case, it's an example where the officer acted reasonably under the totality of the circumstances. He took multiple steps to try to get the warrant, and only once those failed did he then proceed under the exigent warrant, or exigent circumstances example. And then briefly turning to sufficiency, as Your Honor noted, this court considers all evidence, whether properly or improperly admitted. And if there are no further questions, we ask that you affirm. Thank you.
All right. Thank you both for your argument. I think that concludes the morning docket. Court will be in recess until 1:30.
All right.